We now present For the Record.
Welcome to For the Record. I'm Will Keneally. Later in the show, we'll share with you an update on the missing City of Madison ballots from last November. Plus, we look into the enduring legacy of racial covenants that prevented non-white residents from owning homes here in Dane County. But first, we start with the race for state Supreme Court. The current makeup of the court is narrowly divided, favoring the liberals on the bench by a 4-3 margin. And it's a liberal seat that's up this April due to the retiring longtime Justice Ann Walsh Bradley. Now, whoever wins this seat will control the balance of the court. And right now, there are two candidates running in the race for that high court seat: Dane County Judge Susan Crawford, backed by liberals, and Waukesha County Judge Brad Schimel, a former Republican Attorney General, backed by conservatives. Now, we start our series of sit-downs with the candidates running with Susan Crawford. She joins us with more. So I always try and ask candidates, I imagine there's a moment where the switch flipped for you and you said, yes, I want to not be a private citizen anymore and run for public office.
Yeah.
For this Supreme Court seat, what was that moment for you?
Well, really, it was as soon as I heard that the current Justice, Ann Walsh Bradley, had decided not to run again. It took me very little time to make up my mind that this was a seat I wanted to run for, that I was prepared for it, I had the experience for it, and just the desire to help protect the rights of the people of Wisconsin by taking on this role.
I want to kind of get a little bit of a sense of you and your judicial philosophy. Is there a justice or a jurist that you look up to, that you idolize or want to embody their judicial philosophy at all?
Yeah, well, I can think of two examples. At the level of the U.S. Supreme Court, Ruth Bader Ginsburg is somebody who is kind of a hero of mine, both for her advocacy in working to expand rights and get the rights of equal protection for women recognized by the Wisconsin Supreme Court, first as a lawyer and then as a justice. And more locally, Chief Justice Shirley Abrahamson is somebody who I just really revered. I argued cases in front of her when she was on the Wisconsin Supreme Court, and she's somebody with a national reputation, and really made the Wisconsin Supreme Court one of the preeminent state Supreme Courts in the country.
So for those who don't know, and I'm sure you get this a lot as you're out campaigning, I've heard anecdotally people say, oh, it's the Supreme Court, they must deal with these supreme cases like murders, for example. How would you describe somebody, a layperson, a voter, who doesn't necessarily know what your role on the bench would be and the bench's role in Wisconsin?
Yeah, thanks for that. So the Wisconsin Supreme Court every year decides cases that cross every different area of law. And that can be things like election law. It's a common topic to come in front of the Wisconsin Supreme Court. The court currently has 2 cases before it on women's reproductive health care. They can also decide cases of criminal justice, certainly, cases involving protection of the environment, tax law. You know, it just really runs the gamut. But the Supreme Court decides if a case raises an issue of statewide importance, and that's the basis that they apply for deciding whether to hear a case.
So across that gamut, I'm fascinated by judges. You know, you might have to decide an instance of law that you might not agree with ideologically.
Yeah.
Is there one of those cases that stands out for you?
Yeah. You know, I can't think of one off the top of my head, but, you know, I'm a judge right now. I've been on the bench for over 6 years, and you know, I don't decide cases based on politics or based on policy. I decide cases based on the law and also on the facts. You know, it's part of the job of a judge to determine what the truth is in a case. That's the first step, and then I look at what the law is and come to a decision that's, you know, fair, and I apply common sense and make sure I'm making decisions that protect the rights of the parties in front of me.
So you run in this April election, which is nonpartisan. That's where we have all the nonpartisan races. But some of that pretenses have been kind of tossed to the side a little bit, especially recently. Understanding that you're widely considered the liberal-backed candidate, at least, where you have to court some of those liberal votes, but also protect that nonpartisan nature of your role. How do you navigate that?
Yeah, well, one of the most important things to me is making sure that I strictly comply with the judicial code, the ethics code for judges. So that is the way that I protect my fairness, my impartiality, and making sure that I'm not prejudging any cases. So as I'm out talking to voters, I make sure to tell them that, if you ask me a question about how I'm going to decide this case or how I'm going to decide that case, I just won't answer that. I can't. It's really important for judges to keep an open mind until a case is fully submitted and only then make a decision. That's what I do every day as a judge. It's what I'll do on the Supreme Court. And I think that stands in a really stark contrast to the way my opponent's running his campaign. He has had a long career as a partisan politician. He's running this race as if it were a partisan race and telling people how he would decide cases. He has said that the 1849 abortion law in Wisconsin that would operate as a criminal ban to pretty much all abortions is fine, that there's nothing wrong with it and it should be enforced and in effect in Wisconsin today. I think that's improper. There's a case involving that very issue in front of the Wisconsin Supreme Court right now, and by taking positions on it, he's showing that he is not impartial, and it's prejudicial to the parties in that case.
Does it matter that that case might ultimately be decided before he would be seated in this coming August, for example?
Well, there are no guarantees of that. It's likely, but it is not impossible that that case won't be decided yet. So what the judicial rules require is that judges not publicly comment on any case that's pending before the courts. It's just inappropriate to do that.
When we come back, more from our sit-down with Wisconsin Supreme Court candidate Susan Crawford. We'll be right back after this. Welcome back. We stay with the race for Wisconsin Supreme Court, continuing our sit-down with Liberal-backed candidate Dane County Judge Susan Crawford. Here's more. You touched on this a little bit, but recusal has become an issue on the court as well. Can you describe broadly your philosophy on how and when a judge should recuse himself?
Yeah. It's pretty simple. The Judicial Code of Wisconsin lays out what the standards are, what the requirements are for judges to recuse. It's something I do occasionally as a circuit court judge. So occasionally it might be that a party in a case asks me to recuse because they know that I have a relationship with somebody in the case or something like that. Other times I have, in reviewing a file, identified that I know somebody personally, and then I'll take a step back if I believe that I might not be able to be fair in that case. On the Wisconsin Supreme Court, I'll do the same thing. If I'm asked to recuse or if I see something coming up in a case that makes me have to think twice about whether I can be fair or impartial, I'll take a look at that. And I'll apply the law first. So there are some instances where recusal is mandatory, like when a judge has a relationship with a party or a financial stake in the outcome of a case. Those are situations where the judge has to take a step back and recuse. Otherwise, the judge or a justice on the Supreme Court has to make their own determination about whether they can be fair and impartial. And that's what I've always done and what I'll do in the Supreme Court.
If a case that you might have had a hand with in your private practice comes before the court, is that a case like an Act 10 case, for example, that you'd commit to recusing yourself from?
Well, Act 10 is an interesting example. Act 10 is actually a 50-page long act that changes dozens and dozens of different Wisconsin statutes. So it's not one monolithic law. It's a lot of laws. So it would really depend on the facts and circumstances of that case. And if it were something that I had been directly involved in as a lawyer, we just saw Justice Hagedorn do that with the current case. He said, look, I actually wrote this law, I drafted it, and I was involved in a prior legal challenge to exactly the same provision, so I believe I have to step aside. I think that was the right thing for him to do.
Turning now to this idea of stare decisis, we've seen courts, especially Wisconsin and then also federally, overturn previously decided precedent.
Yeah.
How would you describe a time when and where that would be the appropriate course for a court to take?
Yeah, no, I'm happy to do that. The law requires courts, appellate courts like the Wisconsin Supreme Court, to follow precedent unless there's some really good reason not to, some clear mistake of law or something like that. And I think the best example that comes to mind for me is the case Brown versus Board of Education, the case that found that the segregation of our school systems was unconstitutional. And in making that decision, they had to overturn a 19th century case that stood for the excuse me, the proposition that separate but equal is okay under our Constitution. You know, in the Brown case, the court said separate is not equal, and they had to overturn a prior precedent. I think that was correct.
We've also seen recently a handful of essentially voting cases, either voting rights or the process, come before Wisconsin courts. To what extent is there a affirmative right to vote here in Wisconsin?
Yeah. Well, the Wisconsin Constitution does recognize and protect the right of what they call qualified electors to vote in Wisconsin. You know, it's pretty simple. You know, people who are 18 years of age and residents of the state of Wisconsin and not disqualified for some other reason, like, you know, having been convicted of a felony and still serving out a sentence, are qualified electors and have that right to vote. I think, you know, courts often play a role in elections. That is an important check and balance function that the courts play.
One other question for you. Broadly, any cases on the horizon that you could see Wisconsin courts, and especially the Supreme Court, take up that you'd want voters to kind of keep an eye on as they're mulling this choice?
You know, it's an interesting question, Will, and my answer for that is that every case that's decided by the Wisconsin Supreme Court is by definition an important case. That's because the Wisconsin Supreme Court only takes up cases if at least 3 justices have determined that this is an issue of statewide importance. So I just encourage Wisconsin citizens to keep an eye on what their Wisconsin Supreme Court is doing, because every case it decides is important.
Our sit down there with Wisconsin Supreme Court candidate Susan Crawford. Now, coming up next week, we will share our one-on-one sit-down with the conservative-backed candidate in that race, Waukesha County Judge and former Republican Attorney General Brad Schimel. Now, when we come back, we sit down with the co-founder of Own It, a nonprofit that helps Dane County residents of color buy homes. Tiffany Malone joins us right after this. Welcome back. Last week, the Dane County Board approved a resolution recognizing a series of local racial covenants that largely bar non-white residents from owning homes in certain areas of Dane County.
Now, therefore, be it resolved that the Dane County Board of Supervisors repudiates racial and discriminatory covenants as enduring signs of embedded and systemic racism and other discrimination in our society.
Now, this is part of a traveling exhibit that you can see at local public libraries around Dane County that shows the specific areas of the county that have these racial covenants. And right now you can see an interactive map on the Prejudice in Places project on the Dane County website. Now, to be clear, these covenants are unenforceable. Now, a U.S. Supreme Court decision in the 1940s ruled that they are illegal, and last year, actually, Governor Evers signed a law to make them unenforceable here in Wisconsin. But that legacy of discrimination still exists. Joining us now is Tiffany Malone. She's the co-founder of Own It. It's a nonprofit that helps overcome barriers to people of color owning homes in Dane County. She's also a realtor here with Alvarado Real Estate Group. And thanks so much for joining us.
Thanks for having me.
So I do want to kind of get at this heart of the history of this housing discrimination here in Madison. It has kind of that history of being a very progressive city. What does that history look like?
That history looks like basically a lot of hate and discrimination back in the day. And because of this history, a lot of black and brown people were prohibited to live in certain areas of Madison. And that's why you can see the housing prices are so high in certain areas and lower in other areas.
And so we see that resolution at the county level within like the last week or so. Why is it so important? Why is the county taking a look at this right now?
I think it's been a long time coming. I mean, we have people behind the scenes that have advocated for this change for quite some time, and you know, anything in the government moves slowly. But now we can actually get these deeds stricken of all of the bad things that have occurred. Nobody wants to open up some paperwork to their home and see that, hey, no Negro can live here, no Italian person can live here. I think it's disgusting, and it kind of brings us back to how we got to where we are and why the housing statistics are so harsh here in Madison. So black and brown people, I mean, less than 30% own their own homes here compared to non-black and brown people. And that's horrible, and it's because of things like this.
So I know there's kind of these competing ideas of there's housing segregation, certainly, but also then just the ability for people of color to own homes. You think of Milwaukee certainly as being like one of those traditionally segregated cities. How does Madison compare? How's Madison doing right now?
I think we have a group of people who are taking the steps to right the wrongs of the government. Like, that's something that we shouldn't be doing. I'm a realtor by trade, and the history behind home ownership in minorities, it's sad. And a lot of realtors don't know what the history is. Like, there's not a class that we take when we get our license, right? So it's basically self-taught. You usually learn just about fair housing when you get your realtor's license. And if you dive a little deeper, you'll find out things like this happened, you know? Not a lot of people know the history behind Dungeon Monroe and areas like that. Just to see the display and the verbiage and the documents associated with the real estate, it's a lot. It's a lot of money, it's a lot of lost wealth in Black and brown families, and it's a lot of gained wealth in white families, and it's historical.
So when you talk about Dungeon Monroe as a neighborhood in Madison here, what does that look like as just an example of this?
So I would say Dungeon Monroe, Maple Bluff, areas like these, the home prices are $500 and up. Because these home prices are $500 and up, it has a lot to do with the history of what occurred. So historically, Black and brown people could not own in those neighborhoods. The home prices reflect that. It's just evident. And right now, if I wanted to buy a house in one of those areas, I couldn't afford it. But I have lots of peers that live in those areas. And I think that historically, a lot of Black and brown people would have a lot more wealth if they were able to live in those areas in the 30s, 40s, 50s in that area. Mm-hmm.
So kind of looking forward, I know your nonprofit does a lot of work. I believe it's both grants and kind of education, helping people get into these homes. What does that look like on the horizon for us here in Madison-Dane County?
Well, we have closed on 17 homes for 17 families. We are partnered with One City Schools, Anesis, Therapy, and Centro. And basically, we mentor these families. So it's education, and then there's a wealth building aspect of it as well. And there's no restrictions except the restriction that you have to be in one of these, affiliated with one of these schools or companies, right? There's no income limits, there's none of that, but most of the families would not have been able to buy a house without the grant. And just the startup money is important, you know, that's putting equity into their house. So I'm happy about that, and I'd like to see the home ownership rate change here in Dane County. We're working on that. I don't know if we are making a large enough impact like we want to, but we're crawling before we walk. Yeah.
I was going to say, this may be way peering into your crystal ball, but how long do you think it'll take before we start to see some of that change realized? Is it generations?
Yeah.
Yeah.
Mm-hmm. The wealth gap has decreased, not increased. So it'll be generations to come. Our hope is that we won't need Own It Building Black Wealth one day, right? That's our hope. But we do want to get Black and brown families into homes because they have been historically discriminated against, and it's important to us.
Well, Tiffany Malone, thanks so much for joining us. Really appreciate it.
Thank you for having me.
Now, that traveling exhibit starts at the Belleville Public Library in March, and when we come back, a new report from the Wisconsin Elections Commission sheds light on close to 200 ballots in the city of Madison misplaced during the November election. We'll be right back after this. Welcome back. The Wisconsin Elections Commission in January launched an investigation into Madison after it came to light that close to 200 absentee ballots were not counted by the city. Now, the findings of that investigation were published late last week, and we caught up with the chair of the Wisconsin Elections Commission, Ann Jacobs, about those findings.
I think two key things jumped out at me reading through this report. The first of which was that there was sort of a cascade of multiple mistakes, oversights, sort of lack of understanding of the processes that resulted in these ballots not being counted. And the second part which I think is of particular importance, is once the oversight was discovered, sort of the lack of urgency in response to that discovery. And I think that's a big part of this as well. What's a little disturbing to me reading through this is that when mistakes happen, the famous line is the buck stops here. And the idea is that there are people in leadership, when mistakes happen, that they are in charge of fixing them. They're in charge of alerting people. They're in charge of making things right. And it seems to me in reading this report that that sort of level of responsibility we just didn't see from the city of Madison. So I think that's a very distressing part of this report, and I'm certain the commission's going to have a lot to discuss about it.
The commission will review those findings on Friday during their quarterly meeting, and the commission will ultimately decide among a couple of different options, like whether to continue the investigation or declare the Madison City Clerk's actions either compliant or afoul of state law. And that does it for us this week. I'm Will Keneally. Have a great rest of your weekend.
This has been For the Record.